We had, in the initial stage, sought to steer clear of this application for recusal until an affidavit was filed by Juma Okumu, who would not know, exhibiting a letter dated the 30th of April 2025. And this is the reason why, because of that letter, we've not known. This letter by Juma Okumu, the one of 30th April 2025. And Lord, two accusations are made by Okumu in that letter. It's not documented, but 1, 2, 3. At page 3, this is what Okumu says. In particular, and for the avoidance of doubt, one of the defendants in this matter has an agreement with you. This is the letter directed to the court, that a consideration for a favorable outcome, you have already received 30 million, while a balance of 20 million is to be delivered anytime from now. And then he proceeds down, item number 5. He says, Your Lordship has intentionally maintained a close, long-standing relationship with one Victor Kando, counsel for the plaintiff, and one Professor Domo Gender, counsel for the first and second defendants. I know both this counsel, and that's why I say it's an uncomfortable situation. But my Lord, this is what we're faced with.
You know, when the matter came up for hearing first, it was suggested that I hear his chairman for the camera. But I said, let it be heard, open box, with the press, both local, so that those on the occasions pay 30 million can be proved. You know, 30 million is not a shilling. And a balance of 20 million, that's 50 million shillings. By all standards, that's a lot of money. Yeah. That if it fell in my hands, I think I will be a bit confused, because it's a lot of money that I've never seen in my life. So, do you have the evidence? Even you, I know if you get 30 million now, you might think of maybe you have it. I don't know. I might be underestimating you.
No, by all means, it's a lot of money.
It's a lot of money.
But most significant, my Lord, is the accusation.
So if one says that,
my Lord, my argument is quite different. My Lord, my argument is this gentleman has said the court has been given 30 million, the balance of 20 million, and then this gentleman has gone further to say that even my client and my predecessor has a deal with you.
who is your client?
My client is the plaintiff, and my predecessor in this matter is Victor Abano. I'm acting for the plaintiffs.
So the plaintiff has also been in charge.
Yes, that's what has been said. So, my Lord, for the plaintiff.
So this plaintiff is dealing with the judge to get a favorable judgment.
That is what has been said in this letter.
And the defendant is also dealing with the judge?
Yes.
Through Professor Jeda.
No, I am not in
to get a favorable judgment.
Yeah, my Lord, it's a solemn matter. But what the applicant has done is to say that the judge is in cohort with both the plaintiff and the defendant.
So how much has the plaintiff paid for that?
I'm not in the habit of
He's telling you what the defendant has paid the judge. But he's not telling you what he has paid the judge. paid by the plaintiff, paid by the defendant, how many millions?
I don't know. In my entire 22 years of practice, I've never brought money to a judge. So I don't know how money is paid, and I don't care how they are paid. So the point is this, my lord. Our dissatisfaction as the plaintiffs is this. If the lordship rules in our favor, if the lordship rules in our favor in this matter, it will be said it is true. You, the plaintiffs, and are dealing with the judge. We are not making this application, but these are the facts. Now, there is an allegation again by the defendant. My lord, it is quite an unsettling situation. My lord, a judge has a duty to sit and determine disputes. But a judge also has an obligation to disqualify himself if there is a perception of bias or impartiality. And that is not for the preservation of the integrity of the judge, but for the preservation of the integrity of the court. And my lord, permit me to refer you to the Constitution and then to the Code. My lord, the Constitution at article number 50. Every person has the right to have any dispute that can be resolved by the application of the law, decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal body. So this is the fear that this character by the name Juma has brought to these proceedings. My lord, the Judicial Service Code of Conduct. My lord, Professor is speaking very loudly to his assistant counsel. I'm not able to concentrate. My lord, the Judicial Service Code of Conduct and Ethics Regulations 2020 are also applicable in this matter. And significant is Regulation 35. This is what it says. Regulation 35. Judicial officer shall exercise all powers vested in him or her by the Constitution and statute, law, for the maintenance of the dignity of the court and for sustaining the integrity of court processes and the regular discharge of all proceedings coming up before the court. Lord, Regulation 35. And the Lord, to cap up that Regulation 35, the burglary principles of judicial conduct are also imperative. Value number 3 on integrity, that is 3.1 on application. A judge shall ensure that his or her conduct is above reproach in the view of a reasonable observer. This is not our application, my lord. But our point is this. We do not want to be seen to have benefited as a result of these claims, spurious or real. We don't want to be associated with it. So that to prove to any reasonable observer that we, the plaintiffs, have no dealings with the court. We don't want the court to hear the matter further. Otherwise, if we benefit, we'll be accused of having dealt with the court. My lord, to close on the regulations, I refer you to regulation number 47, paragraph 3. 47, paragraph 3. A judicial officer may not recuse himself or herself if, and the operative word is may not, meaning irrespective of the veracity of the grounds upon which recusal is made, the only circumstances in which a judicial officer will say, I will not recuse myself, I must go on with this matter, are two. One, no judicial officer can deal with the case.
Sorry?
One of the grounds where you may not recuse yourself is where there is no other judicial officer who can deal with the case. Here in Nakuru, I believe we have more than 2 judges in the Environment and Land Court. So there is another judicial officer who can deal with the case. Number 2, because of urgent circumstances, failure to act will lead to a serious miscarriage of justice. My Lord, this hearing has been going on. There is nothing urgent. We cannot await in the event that the Lordship says, let the matter be handled by another judge. My Lord, it is on that basis, therefore.
What if the magistrate judgment?
If the magistrate judgment, it can still be sent.
We've had all the parties, all the witnesses. What's pending that judgment? Does it also fall under?
Yes.
Yes.
Yes, because if a matter is not determined, it's still subject to procedures. And my Lord, I emphasize on our part as the plaintiff, we know we have a very good case. We don't have a problem with the court, but we don't want a judgment that will take us to the DSC. We don't want that judgment. We don't want anything to do with it.
You don't want a judgment that tells you? Yes.
Take us as the plaintiff to the
This
DSC.
is the truth of the case.
Prof, you have your time.
Advising me.
Did you hear me read Matthew chapter 27, verse 24? We don't want anything to do with this thing. So, my Lord, lastly, this is the point. You are like King Solomon. The 2 ladies have come to you. Each had an infant. One has died. You need to determine who of these 2 ladies will go with the child. You know how King Solomon dealt with the matter. But for us, the plaintiffs, we reiterate like Pontius Pilate, we do not want anything to do with this matter. It's been defined, whether spurious or real, it makes our participation in this matter very delicate. So for that reason, my Lord, whether or not you find merit in the application, I think the prudent thing to do is to let go of the matter. Send it to another judge. It's not worth the fight, by all means.